5 seconds to go. Start. No court shall take cognizance of any offence punishable under section 138 except upon a complaint in writing made by the payee or, as the case may be, the holder in due course of the cheque. Such complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso to section 138, provided that the cognizance of a complaint may be taken by the court after the prescribed period if the complainant satisfies the court that he had sufficient cause for not making a complaint within such period. No court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try any offence punishable under section 138. We must say at the inception that the respondent, not having disputed his signatures on the cheques, it was for the respondent to show in what circumstances the cheques had been issued, that is, why was it not a cheque issued in due course. The words of section 139 of the NI Act are quite clear that unless the contrary is proved, it shall be presumed that the holder of the cheque received the cheque of the nature referred to in section 138 for the discharge in whole or in part of any debt or other liability. The respondent has not set up a case that the nature of transaction was of the nature which fell beyond the scope of section 138. Other than taking a technical objection, really nothing has been said on the substantive aspect. The only eligibility criteria prescribed under section 142(1)(a) is that the complaint must be by the payee or the holder in due course. In the conspectus of the aforesaid principles, we have to deal with the plea of the respondent that the complaint was not filed by the competent complainant, as it is the case that the loan was advanced by the company. As to what would be the governing principles in respect of a corporate entity which seeks to file the complaint, an elucidation can be found in the judgment of this court in Associated Cement Company Limited versus Keshavanond. If a complaint was made in the name of the company, it is necessary that a natural person represents such juristic person in the court, and the court looks upon the natural person for all practical purposes. It is in this context that observations were made that the body corporate is a de jure complainant while the human being is a de facto complainant to represent the former in the court proceedings. Thus, no magistrate could insist that the particular person whose statement was taken on oath alone can continue to represent the company till the end of the proceedings. Not only that, even if there was initially no authority the company can at any stage rectify that defect by sending a competent person. The aforesaid judgment was also taken note of in a subsequent judgment of this court in MMTC Limited and another versus Medchal Chemicals and Pharma Private Limited and another. We find that the judicial precedents cited aforesaid have been breached by the courts below. The High Court also embarked on a discussion as to the vagueness of the identity of the complainant and its relation with the legality of a loan which may be granted by the company, something that was not required to be gone into. If we look at the format of the complaint which we have extracted aforesaid, it is quite apparent that the managing director has filed the complaint on behalf of the company. There could be a format where the company's name is described first, suing through the managing director, but there cannot be a fundamental defect merely because the name of the managing director is stated first, followed by the post held in the company. It is also relevant to note that a copy of the board resolution was filed along with the complaint. An affidavit had been brought on record in the trial court by the company affirming to the factum of authorisation in favour of the managing director. A manager or a managing director ordinarily by the very nomenclature can be taken to be the person in charge of the affairs company for its day-to-day management, and within the activity would certainly be calling the act of approaching the court either under civil law or criminal law for setting the trial. Stop.